regarding the Mollett case. This is a case where the legal services system of New Jersey worked to optimum results. Ms. Mollett, who had a handicapped child, was being evicted for habitual late payment of rent, called a hotline number at L&J. The hotline screened her, saw that she needed an attorney. She was about to be evicted. I guess it might have been like a Thursday. She was about to be evicted on Monday. They contacted me. Jose, we have this emergency. This senior citizen with a disabled child is facing eviction for habitual late payment of rent. And based on what she's telling us over the phone, it seems like there was no basis for it. Immediately got in contact with the client, had an appointment for her to come in. At the time, we had limited resources, but talking to the client and realizing that this wasn't an habitual late payment of rent. There was no lease agreement that said when the rent was due. The client was saying, you know, I've been there for 30 years. I always pay my rent on the 18th of the month. And the reason why I pay my rent late for 2 or 3 months was because I had habitability issues. I have a working toilet. I had other problems. But the judge didn't even listen to me and entered a judgment against me. So I told Ms. Mollett, well, we're going to have to do an emergency order show cause to try to stop the eviction and schedule the case in court, reopen the case. That weekend, I worked on the case and prepared the certification outlining the case law on it. When we went to court, I was a little bit disturbed that my adversary and the court, it seemed like they had a prior relationship. So I kind of like suspected that I would probably lose on the case. Basically, the court didn't review our papers, and the judge said, I'm not going to reverse, but I will give you a stay to go to the appellate division. So we went to the appellate division, the case went up, and basically the court held that there was an issue regarding when was the rent due. It was a new landlord who was trying to enforce a due date of the first, even though there was no written lease, even though the course of conduct between the tenant and the prior landlord was the rent was due on the 18th. And then there was also the issues about the conditions of the apartment. So the appellate division agreed with our position that you can assert a Marini defense in a habitual late payment of rent case. That is a defense. Again, looking at the law, it says you're habitually paying your rent late without legal justification. And well, you know, if you were holding your rent because you need repairs, that falls under legal justification. The trial court disagreed, but thank God the appellate division agreed with us and reversed. And she was able to remain in her apartment where she lived for 30 years. I think the pretext of that case was because she lived there for 30 years and she was a rent-controlled tenant, her rent was $300 a month. So you had a new landlord coming, it was a new landlord from Brooklyn, coming in, trying to find some reason to try to evict this tenant so he can raise it to market. And thankfully, the system worked. She got legal representation and we were able to prevail in that case.